special special meeting for council. I'd like to call the meeting to order and note that all of council, with the exception of Councilor Malante, is present. Can I get a motion for the adoption of the agenda?
I'll move adoption of the agenda.
Thank you. All in favor? Carried. All right, 4.1. I'd like to welcome Kevin and Ruth from Municipal Affairs, and feel free to start off. Thank you so much.
Thank you, Your Worship, and good morning to yourself and to members of council. My name is Kevin Miller. I am the manager of the accountability team at Alberta Municipal Affairs. With me today is Ruth McCraig, who's one of our accountability advisors, as well as Namdi Abalane. And we also have from our advisory team, we brought Jordan Velaston as well, who is a financial advisor specifically. So we work to deliver the municipal accountability program as well as legislative compliance checks here in the province of Alberta. As you are well aware, I'm sure, the Municipal Government Act provides the legislative framework for the operation of local government here in the province of Alberta and has many mandatory requirements that can be very difficult to manage, especially in small municipalities. So as a result, in 2018, we introduced what's called the Municipal Accountability Program. The Municipal Accountability Program is a mandatory program for all municipalities under 2,500 population, and every municipality takes part of this once every approximately 5 years, give or take. And since the inception of this program, we've done almost 300 reviews. So we are a very experienced team with dealing with legislative compliance here in the province of Alberta. In 2023, we expanded the Municipal Accountability Program to include what's also called the Legislative Compliance Check, which is what we're here delivering today. The Legislative Compliance Check is designed for municipalities that do not otherwise qualify for the Municipal Accountability Program, so your population threshold is too high for us. There are a few ways that a municipality can find themselves in an LCC. There could be concerns with tax rate bylaws, later missing financial reporting, things like CAO turnover as well, or as part of a viability review as an example, or as in the case here in the town of Gibbons, by request of the municipal council for us to come in and do a check to see how your bylaws, your policies, and your procedures are shaping up against the requirements of the Municipal Government Act. So to be very, very clear, this program is intended to be educational and supportive of our Alberta municipalities. This is not a program that goes, you know, Colonel Mustard did it in the library with a candlestick. This is to identify things that are and are not being done in accordance with the Municipal Government Act, identify those things, and help and support a municipality in remedying those things. Unlike a municipal inspection, things do not lead to municipal directives. So the minister is not going to be pursuing any orders here in the town of Gibbons saying you must do certain things. However, of course, compliance with the Municipal Government Act is of course mandatory, so those items that we've identified as not meeting legislative standards do need to be addressed by the municipality as well. The final thing I want to say is this report does represent a point in time. And specifically, that point in time is June 12th of 2025, when we did our interviews with your administration and when we gathered the documentation. So it's our understanding that this council and this administration has already done some actions that may address things that are included in this report, and that's perfectly fine. We still include them because, as I say, this is a point in time as of June 12th. So with that, I am going to turn this over to Ruth, who is the lead on this legislative compliance check and the main person that has gone through, done all the interviews and done all the writing for this. So without any further ado.
Thank you, Kevin. Your Worship, members of council, members of the public. So when we are talking about the report, we refer to something called a gap, and a gap is simply an area where the town is not fully compliant with the requirements of the legislation. Where there is specific action that must be taken to ensure the town is in compliance, these actions are specified in the report. There are some cases where action is not, there is no authority to require action under the legislation, where action is not possible. In that case, it's addressed as a go forward matter, and those are reflected within the report. I'm going to jump ahead to the next steps. So the letter that, the minister's letter that was delivered today reflects the 8 weeks from the date of the letter. The letter is dated September 18th, but due to various circumstances, that obviously that 8-week date is not kick in until today. And that is 8 weeks for administration to review the report and come up with a response plan. And given that this was requested by council, it would not be unexpected that council, approves the response plan or has thoughts on the response plan. We recognize that this is obviously going to happen probably with the next council. But municipal affairs requests a response with a plan within 8 weeks. The plan can take up to a year, because we recognize that the municipal administrative cycle is an annual thing. So if you have a gap in your tax rate bylaw, we're not going to request that you fix it now, or that you reissue your tax notices now if there's a line missing from your tax notices. And circumstances happen, staff changes, fires, floods, life, council decides, I think we're going to actually rewrite our whole land use bylaw. If it should turn out that you require more time, that is something that we are happy to accommodate. We work collaboratively with your administration. If they're trying to address a gap and they have a bylaw that they're not sure is legislatively compliant, we're happy to look it over and go, tick, 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 tick. Yes, this meets all the listed requirements of the legislation. We don't have a comment on best practices or whether this is a good idea for the municipality. That's absolutely not our role. We just say, the MGA says this, your bylaw says this, you're good to go, or you need to look at it. So this report reflects that there were 27 legislative gaps identified. This figure falls within the normal range for a municipality that's not had this kind of review before. And having done in the order of 300 of these, we see a lot of the same material in municipalities. So much of this is not new to us. You are, in many respects, extremely normal. You are profoundly normal, if that helps. I do realize that there are some specific areas of the report that may be of specific interest, and council may want to ask a number of questions. So in order to get through the majority of the report, I've withheld those until the end, so we're just going to defer them if chair has no objection. So with that, the report starts on page 9. As council named a place with as the municipal office, this is identified as a gap. We could not find any resolution doing this. We have had municipalities that have moved their municipal offices, and we could not find them for 3 months. And nobody could get a hold of them. So it's not only a matter for municipal affairs, but also your residents probably want to know where to direct their mail and stop and pick up bills and ask questions. Signing of municipal documents with the appropriate authorities and designated officers, and signing of bylaws. This matter was reviewed and there were no concerns. Provision of information. When and how the CAO must deliver information to council. Again, this was reviewed and there were no concerns. Meeting and procedures, a note was identified. There is a requirement in the MGA that a resolution to enter closed session must include the exception of disclosure within the resolution itself. That is not currently the practice of the town. So it would be Councillor Smith moves to close council to the public under exception 27 of Division 2 of the ATIA. So it's not within the body of the thing, it's within the resolution itself. And again, this is a very, very common finding. So you are, in that respect, profoundly normal.
Can we ask questions as you're speaking, or should we jot them down and ask, what would you prefer?
That's to the chair. How would you prefer to proceed?
Because you're going kind of fast, so,
Oh,
yeah.
it's true.
I think my gut is saying, why don't we hold off till the end? Just write them down, and then
Sure.
we'll come back to it.
Okay.
Let you have your flow, and then.
No, and that's
that way we're
fine, and
not
I realize
interrupting
that,
the flow.
there may be something that, people, public hearings. The minutes showed that this was not actually held during a special or regular council meeting. That is a requirement of the MGA. What we often see is that a meeting is held either separately outside, or the meeting is for some reason recessed or postponed, and then the public meeting is held. the council meeting is the only place that a council can make decisions. So if they are not within a regular or special council meeting, they are not a decision-making body. And for that reason, public hearings must be during, as part of a regular or special council meeting. Public participation policy. There were some gaps identified with respect to this in terms of information and practices. It is somewhat incomplete. So this is a gap identified, and this policy will need to be reviewed and the required categories of participation added. Provision of regular meetings. Council passed a resolution at your organizational meeting last night setting the, last year. The resolution did not specify the time of the meeting or the location. Not all members of council are present. Regular council meetings are only created when a resolution is date, time, and place, and all members of council must be present. You do not have to do this at your organizational meeting, although it is most common, but those are the four requirements for something to be established as a regular council meeting. If it's not a regular, it's a special council meeting. Again, very, very common gap to miss one of the elements or have a council member away and not present. The organizational meeting, last year, other aspects with respect to the appointment of a chief elected official and the appointment under their own name, this was reviewed and found to be compliant. Special council meetings. Special council meetings are called with the appropriate notice, notice given to the public, and the agenda of the meeting is not changed without the consent of 2/3 of council. That is compliant. Quorum. The minutes show that the majority of council is in fact present to exercise their authority to act. Again, there are no concerns in this matter. Authority to act. The minutes of January of this year showed that a meeting was canceled without a resolution of council. Council may only act by resolution or bylaw at a duly constituted meeting. So absent that, it's not a valid practice or a compliant practice. Again, last year, there was a resolution to hold a special council meeting. It was canceled again without resolution of council. There is a note reflecting a letter received in May 27th, 2024, that was ratified, I gather, over email. Again, this is not a compliant practice with the MGA. So going forward, council must only act at a meeting by resolution or bylaw. Voting. The minutes of last year showed that a council recused themselves from adopting the minutes on the grounds that they were not permitted, they were not present during the meeting. This is contrary to the MGA. The limits, the times that a councillor may recuse themselves are very specific and very limited, and that does not fall under that. So again, this is a practice that is contrary to the compliance with the MGA. Council meeting minutes. The minutes are prepared and stored securely as required by the legislation. Pecuniary and conflict of interest. Legislation has broadened to expand the definition of pecuniary, strictly financial, conflict, or perceived conflict of interest, and that is left to the discretion of the councillor and cannot be questioned. However, when a councillor is declaring any form of interest, the nature of the interest must be recorded in the minutes. It is insufficient to say, Councillor Smith declared a pecuniary interest and recused themselves from the meeting. The nature has to be stated, in that the decision may affect their employer or a member of their family or they are a business associate, so they feel they have a conflict. So the general nature needs to be reflected in the minutes. Bylaw procedures. Bylaws are adopted in conformance with the legislation. Bylaws are amended and repealed and revised in accordance with the legislation. The mandatory bylaws, the chief administrative bylaw, and the appointment of the CAO were in accordance with the legislation. Bylaw enforcement officers. The bylaw enforcement officer bylaw is compliant. However, the bylaw enforcement officers must take the official oath as required under the Oaths of Office Act. I recently received an email from the town indicating that this has now happened, but again, this is point in time as of June. So when this is recorded, we will reflect that this is actually since been addressed. Procedural bylaw. So the council procedural bylaw has a number of gaps. Whether council wishes to address this now or leave it for the next council is of course the option of council. The bylaw says that provisions of the bylaw may be waived by resolution. A bylaw may only be amended by another bylaw. So there is no specific provision in the legislation that says you can just decide not to follow the bylaw. There's a section in the bylaw that talks about breaches of order. The recent revisions of the MGA require that any clauses in a bylaw relating to the conduct of members must be removed by November 15th.
Sorry, can you repeat that part? I just didn't understand it.
Okay, so when the codes of conduct were repealed on June 15th of this year, there is a clause that's added that says any code of conduct is considered repealed. Any bylaw that has any clause that governs the conduct of member, and there are several in your bylaw, must be amended within 6 months of passage, so that would be November 15th. So your provisions on asking a member to leave or recording that the member has been out of order, the legislation, the MGA now requires that those be removed.
Oh, okay.
There is a clause in the bylaw that says the mayor, or in the absence of the mayor, the deputy is an ex officio member of all committees. There is a change in the Municipal Government Act. Some boards and committees must be appointed to in their personal name, and that's anything to do with planning and development. So that's your MPC, your SDAB, specifically the ones that require training. You can't just have anybody show up and have a vote. So there's now a restriction on that, and the details of that are laid out in my notes. There is also a clause in the bylaw allowing the consolidation of bylaws. Consolidation of bylaws is certainly something that is authorized under the Municipal Government Act, but it must be delegated to a designated officer, and this doesn't specify that it is a designated officer. It basically lets anybody go in and play with bylaws. So it needs to be the required structure on that. And there's a note that the bylaw currently uses the term in camera. That term has changed to closed session. It's certainly not a gap. Whether council chooses to use that term is completely at your option. Meetings by electronic means. At the time of the review, there is no bylaw adopted for conducting council meetings where all people attend electronically, or for the provision of hearings held by electronic means. We are going to move to page 33. Three-year operating and 5-year capital plans. The financial plan for the upcoming 3 years covers the required 3 years, has most of the information. one of the requirements for a 3-year financial plan is that it includes the annual anticipated surplus or deficit, and at the end of the 3 years, the accumulated surplus and deficit. So basically, it's a snapshot of if things go as we're thinking, this is where we would be in 3 years. And obviously, that gives council a chance to make any, it's like, according to this, we're gonna be down by $723,000 in 3 years. What changes do we need to make in the interim if this happens as we expect? Again, missing the accumulated and annual surplus and deficit, extremely common oversight. Capital plan, your current capital plan meets all the requirements for timing, but it does not have the anticipated sources of revenue, which is one of the requirements of the regulation. Audited financial statements, financial information return. We look for a limited list of very specific items when we review your financial statement with respect to, did you receive a letter with any concerns? Is your debt limit recorded? Sorry, my brain just ground to a halt. And our designated officers and council and the CAO's salary and benefits recorded appropriately. And again, there were no concerns. So that's these next 2 pages. Financial records and receipts, yes, there is a process and place for the recording and accounting for financial records and receipts, so there were no concerns. Same as municipal accounts. I gather that administration and council may have recently made some changes to this process, but in fact, a financial institution has in fact been designated. A fidelity bond, yes, the municipality does have the required insurance. Investments, as the municipality does not at present have any investments, this was reviewed, and no concerns. Disposal of land. Municipality disposed of some land this year, and that was done in accordance with the requirements of the MGA. We will now move forward to 44. A loan guarantee, which is essentially your co-signing on behalf of a nonprofit. The curling club needs a new rink, needs a new roof. They need to borrow the money, but they need someone to guarantee the loan. No, the municipality has not in fact done this. So, assessment and taxation. The assessor assigned the assessment classes in accordance with the MGA and any subclass bylaws. You don't have a subclass bylaw, so again, no concerns. The assessor does in fact prepare an assessment roll as required by the legislation. It is available for view. The tax roll is also prepared in accordance with the requirements of the legislation. Property tax bylaw. There were a couple of gaps identified in your property tax bylaw. So there are revenues in the form of a requisition allowance. And for those that may not be familiar with a requisition allowance, it is a budgeted amount to cover a shortfall where taxes are not collected, but the municipality is on the hook for the requisitions for housing and in this case, it applies only to education, and that allows that to increase the amount collected under the education requisition to offset that so that the municipality is not responsible for those. It's appropriate to have it in your tax rate bylaw. However, that figure was not reflected in the budget. So anything that's not in it must be in the budget in order to be in the tax rate bylaw. That is your authority on which the tax rate bylaw rests. So again, not an uncommon thing that we see, but a change that would have to be made. The tax rate bylaw also includes some subclasses, namely residential vacant and non-residential vacant, that are not established by a subclassification bylaw. And the rate for designated industrial property was not as set out in the requirement under the ministerial order. This is something that we discussed with administration, and that misunderstanding has since been clarified. Assessment notices. Assessment notices are prepared and sent as required by the legislation. The tax notice, there is some information missing from the tax notice, specifically how to file a complaint and how to request a receipt. Again, something that, you know, as time and processes evolve and people, well, why do we have this on there? Or new format, this falls off. Again, a very common certification of tax and assessment notices. A designated officer has to certify over their signature the date that tax and assessment notices were mailed. And there's no format for that. It can be simply, I've seen multiple ways to do it, but that is the source of truth. If somebody was to say, when did you mail this? I certified it. Assessment review boards. Your assessment, you are among the 87% of municipalities that encounter a gap on assessment review boards in their first visit or their first legislative review. So you are far from alone. Your bylaw itself is completely compliant with the legislation. However, there are requirements for certain appointments to the board, and we were not able to find resolutions reflecting those appointments. So that's the term of the members or the chair, the required number of members appointed to the board, and the appointment of the clerk. So, just some missing parts. Again, there's many ways that this can be resolved, and that's something if council administration has any questions on how this could be done, whether they would prefer to delegate it to, if you're part of a partnership, that's certainly something that we can address or assist with. Tax payment and tax penalty bylaws. These were reviewed and found to be completely compliant. And we're going to skip over to page 56. Tax recovery. Yes?
Why would we skip over to page 56, because it seems like the other municipal taxation authorities.
That's an area that that's an area that we're going to talk about when we talk about the larger financial questions. Tax recovery. With respect to tax recovery for land and residential properties, the municipality is compliant with those processes. However, the municipality has not yet addressed tax recovery with respect to designated manufactured homes. And those are separated because they are two slightly different processes in terms of who is notified. One is a lien, one is with service registries, so it's slightly different process, so they're handled differently under the legislation. The municipality is completely compliant on the one side, but there are a couple of gaps on the manufactured home side. Tax recovery auctions related to land, again, this is completely compliant, but there have been no tax recovery auctions or tax recovery action with respect to designated manufactured homes, so again, this is noted as a gap. Tax agreements. Municipality has in fact entered into tax agreements. What was noted as a gap was that the term of the agreement, which must be no more than 3 years, that piece of information was missing. So again, a very small thing, but necessary because there is that specification in the Act. Planning and development. Your municipal development plan is completely compliant. It includes all the parts required by the MGA. Your land use bylaw. No, the only issue that was identified within the land use bylaw was that there has been a legislative change to the appeal period for a development permit. It was formerly set at 14 days, it is now 21 days. But aside from that, it includes all of the required elements of a land use bylaw, but that will need to be amended at some future time. Council has in fact provided for subdivision and development authorities, so those two next pages are compliance. Council has a subdivision and development appeal board bylaw and has appointed a clerk as required. Again, this is completely compliant with the provisions of the Municipal Government Act.
I just have a question, and I'm sorry to interrupt, and I know that but some of the, this one in particular, the subdivision authority and the development authority, you're saying back to, the bylaw, 1-25 that was passed February 12th. Now, prior to, our CAO is gone for a reason, and, back in, end of January 2023, I wasn't present at this meeting, but he brought forward an approving authorities bylaw, which, contrary to what you have here, designated himself as the subdivision authority and the development authority. So prior to February 12th of 2025, this was not in compliance. And so,
If I may, it is extremely common for the CAO to be the Planning and Development Authority, Subdivision and Development Authority.
Were you aware of the approving authorities bylaw though, because it was sweeping?
Yes, but it's my understanding that that bylaw is no longer in effect.
Okay, but it has this grave effect on what had happened from January of.
But that is outside the purview of this review.
If I may, again, this is a point-in-time review as of June 12th of 2025. So, something going into a, 2024 in the past of a rescinded bylaw, that is not something we're going to review at all as part of this program. It does not fit that point in time.
But we're here because we asked you to actually do a municipal inspection, not a legislative compliance review. Okay, so anyway, sorry, carry on.
Okay, so there is nothing legislatively contrary to the Chief Administrative Officer being the Subdivision and Development Authority. In smaller municipalities, in fact, it's extremely common.
Does that include being able to circumvent council direct control districts?
It should not.
Well, it did.
Well, but again, point in time, and that has since been rectified, and that is even a municipal inspection would not go back and examine the impact of a repealed bylaw that's to
And
be.
if I may too, without actually looking at this bylaw specifically, so I am talking off the top of my head just with legislative knowledge here, but council has the authority under the Municipal Government Act by bylaw to delegate almost all of council's powers, duties, and functions. There are a couple in there that you can't delegate, one of them being the power to appoint or suspend a CAO, another being the power to pass budgets and those types of things. But if this was in a bylaw, if council delegated their authority to another person of their power, as long as there's not something else in the act, and I'm going off the top
Oh,
of
no,
my
I
memory
understand
here,
it's council's
so-
responsibility. They ultimately made the.
But council delegated their authority in that case. It is not one of the 5 thou shalt not delegate. So if council opted to do that,
Oh, no, that makes. I
there
just wanted
appears to be,
clear-
based
clear.
on simply the information here, I wouldn't see a legislative non-compliance in that.
Thank you.
Listing and publishing decisions, policies to make planning decisions. The Town of Gibbons website does not currently comply with this requirement. There is a requirement that bylaws and policies used to make planning decisions and any documents used in reference, so if your land use bylaw references an ALSA or an area structure or the MGA, those also need to be included. There also needs to be a description of the hierarchy of authority on which supersedes the other. So somebody can't say, well, you have this policy, so I can do this. where actually it's only contextual based on if, then. And this provision has been tested in court, and the municipality that did not publish by reference something they relied on was found liable and had to repay the developer. Now, that was the city of Calgary, but, so it is something that is relied on in court, so. Off-site levies, the town at the time of this writing, I don't know whether that's still the case, had an off-site levy bylaw that was adopted in 2008. This is in fact contrary to the MGA. It does not include provisions for regular review and an updating of the formula as required by the legislation. Municipal planning commissions. This was reviewed and there were no concerns identified. Similar to your area structure plan. Again, there's no concerns identified. You do not have an area redevelopment plan. And the remaining portions of the main body of the report are information for discussion only on reserves, when things can be added to the tax roll, and general information with respect to joint use and planning. So with that in mind, I will ask council to return to page 30, please. So there were two gaps identified in, with respect to the legislative requirements of the operating budget. The first is that there is a local improvement tax bylaw, but those figures are not reflected in the budget as required. The second was that the tax rate bylaw includes the requisition allowance, but that figure is in fact not reflected in the budget. So there, it also did not include the amount to be transferred from reserves. The capital budget reflects that some things are funded from reserves, but there's no provision in the operating bylaw for that amount to be removed, which leads to an imbalance of the actual status of the reserves. Capital budget, there was a resolution last December to adopt an interim capital budget. In 2022, a very small but significant change was made to the MGA that says by January 1st, the capital budget must be adopted by January 1st. Unlike an operating budget, there's no provision for an interim. It is the capital budget. However, council is always able to revise that at any point in time. But what this does, in fact, is give council the authority to, in March, start hiring engineering and doing studies and whatnot, and they have the actual budgeted authority for that. Our next page is page 41, borrowing. So as council is well aware, there are a number of outstanding borrowing bylaws. With respect to the required structure of the bylaws in terms of the term being accurately reflected, the rate of interest expressed as a percentage being being reflected in the bylaw, a number of those structural items are missing from several of the bylaws. Again, this is something that we commonly see with respect to borrowing bylaws. People like to say prime plus one or whatever. The legislation is very specific. And by capping that, it prevents municipalities from discovering that all of a sudden they're paying 23% when they didn't expect to. It lets them to self-govern. For some of the borrowing bylaws, a borrowing bylaw for a capital project must be included in a budget. There were a couple of bylaws where this did not happen. It's been going back for some of the older ones from 2023 forward. So again, this is a requirement of the MGA. There were a couple of cases where bylaws had expired but were still being utilized. Again, that's a very simple correction. Again, that is something that we see. I just had a conversation with a municipality very recently to go, hey, did you know you actually need to do this? This has a defined term. And where a capital borrowing is done, the project must be reflected in the budget and in the capital plan. And there were a couple of bylaws where that did not happen. Again, so the matters with specific bylaws are reflected here. In some cases, and I can't speak to the agreement that you may have with your lending institution, whether you can amend the bylaw to reflect these terms and include that required information is something that if you cannot correct it, it would be a go forward thing. Going forward, you must. If you can correct it, you should, but if you can't, there's a couple of bylaws where it was not reflected in the budget. Again, once that bylaw is passed, within 30 days, it's not appealable in court. So there is no legislative authority for the minister or the courts to take any action on those bylaws, but it's very much a go forward. Now that it's been identified, at the time of the report, there was some indication that Municipal Affairs was not certain as to whether the town had in fact exceeded their debt limit. It is our understanding that the town is now within their debt limit, so in that respect, our financial advisor has been working closely with administration to determine if an additional debt limit extension was required. It is our understanding that that has now been resolved. So, again, there's no action going forward since the municipality has since taken the necessary steps. Loans, as council is aware, there are some loans to private individuals. Again, this is contrary to the MGA. A municipality can only lend money to a nonprofit or to one of their own organizations, or to, an MCC. There's a very limited list of to whom they can loan money, and that does not include private individuals. Again, this is an identified gap. There is no legislative remedy that we can require. That is a question to the municipality, whether they're going to incur additional liability. But again, this is a go-forward thing. There is nothing that we can say that you can or must do, but you must stop.
When you say must stop.
No, you must not do it again.
Sorry about.
No, you must do it again. You must not do it again.
So in the, as it stands right now, as it stands right now, the loans that are out there, we leave them?
We cannot require you to do anything to it. There's no legislative action that we can say you must do this, this, and this. If there is action that you can do, you should absolutely do it, but we recognize that there are other matters of liability or what have you that we have no say or control over.
Okay.
Other municipal taxation authorities, there are, sorry, page 54, thank you, Kevin. I have tabs. So there are a couple of local improvement bylaws. They are, there was some gaps were identified with respect to how these bylaws are set up. A local improvement bylaw has very specific requirements for the area that is affected, who is liable to pay, the period over which this is done. There's one bylaw that says it could be 5 or 10 years. No, it must be very, very specific in what it lays out. One of the bylaws has already been amended once, and the legislation says you're only allowed to amend it once, so there's no legislative action that can be taken to address that. In some of the cases, the municipal contribution was reflected at 0. It's our understanding that there was in fact a municipal component that is not reflected in the bylaw, but again, that's a more of an internal than a municipal affairs matter. We were also not able to find a tax roll that actually imposed the taxes levied. So this can be on the regular tax roll or another tax roll. It's our understanding that the practice was to issue an invoice. No, this is a tax. It requires a tax notice and a tax levy. And if it is not paid, then it is the same as any other thing and is subject to tax recovery action. And that covers, in a 45 minutes or less, the fundamental findings. Again, these are very detailed, where the municipality is doing things correctly. It lays out, it says, we looked at this, and this is in fact what you are doing right. Where there is a gap identified, it identifies the gap, the legislative reference, and the action that must be taken. I will now turn to the chair and ask if he has any questions.
All right, thank you so much. Okay, so I don't know if everybody was like me, but as you were going through page by page, I was just writing questions down at the
Yep,
top.
for sure.
So are we all okay if I just start at page 9? Let's see if anybody's got questions on that one, and we just continue through. That sound fair? Okay, so page 9, municipal office mandatory. I know we've already actually made that change on the bylaw already a month and a half ago, something like that. So I think we're okay there, but any questions on 9, 10, 11? My first question came on page 12, so,
I do.
okay.
Is this, for signing of municipal documents and whatnot, is there, I just would like to, the definition of a designated officer, does that person have to be an employee?
No,
Okay, so it
You're-
could be a consultant?
absolutely. Your assessor is a designated officer, and they're rarely an employee of the municipality. They are required to be a designated officer.
Okay, good, thank you. Maybe for the audience, could you maybe define what a designated officer means? I know, and we all know, but.
A designated officer has to be created by bylaw, and they are given, often they're delegated certain authorities of council. A designated officer must be the person that signs minutes, bylaws, and checks, agreements, and other negotiable instruments on behalf of the municipality. So those must be established as a designated officer by bylaw.
Good.
Follow-up question on that.
Sure.
Is the designated officer have to be named or by position is acceptable?
Either is acceptable.
Okay.
Many municipalities opt to do it by position, so they don't have to revise the bylaw when they change employee.
Wonderful. Any other questions on that one? Okay, page 12, my first one, on the closed meetings.
Yes,
You had made a mention that when we move into closed meeting, we have to basically state the ATIA section that's causing that. What if we're going in with multiple topics? Do we have to list them all?
yes,
Perfect.
yes.
Any other questions on that one?
When coming out of a closed session and returning back to an open meeting, any motions that are arising from the discussion that we had in the closed session, oftentimes it's our previous CAO had, we're at the sort of the mercy of that position, right? We were told that we just come out and we can accept an item for information as opposed to be, a little bit more specific on what the item was. So I suppose if we have to, a personnel item with X, section of the act cited is pretty vague. So when we come out of the in camera, what is the way that we've been, sort of finalizing that discussion and accepting that as information or whatnot? Is that acceptable, or should we be a little bit more specific? Like direct administration to do as discussed is.
If you are providing direction to administration, it must certainly be couched in that form, that you are providing direction to administration.
But what for is what we don't regularly do.
The legislation doesn't specify. We have a lovely document down at Municipal Affairs on closed sessions of council that provides some best practice and guidance. I say.
Do you know what I mean? If because oftentimes, we've come out of an in-camera session and passed a borrowing bylaw or whatnot, right? So it but, I mean, there have been some pretty important, items discussed in an in-camera session that when we come out of that, it's like I said, it's regularly accept as information as opposed to, I mean, the whole point of returning to the.
Okay, I'm gonna ask Kevin to do this because he's been doing this for 7 years, so he's been a CAO, he's been there, done that.
So the legislation itself doesn't explicitly talk to how your resolutions need to be worded and such. The one thing that we would always say, and this would be a best practice in general, is your resolution should contain enough detail for what it is the council is wanting to do about that item. So for example, like imagine for a moment if council was in a closed session, you come out of that closed session, you provide a direction, and then a asteroid literally lands on this and takes out almost everybody sitting here. Who's going to take on that action, and how can they do it if there's not something in the resolution that tells them what they're supposed to be doing? Accepting as information would generally be that council is just accepting information. So we've given you a 60-some-odd page thing, and if you don't have an action at the end of the council meeting tonight, other than the fact that we're going to review this and do some stuff, you may very well accept this report as information. And that then is, we've received this. That is not taking an action on it, though. So if you're in a closed session and you go, we want administration to do these 4 things, when you come out of that closed session, your resolution should likely specify those 4 things.
Okay, yeah, because it's either the accept as information that was regular practice, or direct as administration as discussed, or direct the mayor as discussed, right?
Even potentially this should go, and now I want to be very clear, I'm talking about best practice here, I'm not talking about a legislative requirement. But your resolution should be clear. So as discussed, if I was picking up the reins from your CAO the next day, that doesn't tell me anything. There's nothing that I can do off of that. I don't know what the action is.
Okay.
By the time that you're doing action, you should probably be able to actually say what that action is, even if the conversation has things that needed to be shielded because of closed session.
Okay, that makes sense. That's quite important going forward thank you.
All right. That was page 12 for the closed meetings. Anything else on that? 13. 14. So I do have a question on this one, the public participation policy. You made mention that there were things missing, but I don't know if I caught what we were actually missing.
I did go into it detail. If you look at the recommendation section, it says that it's missing types or categories of approaches the municipality will use, and the categories of circumstances that the municipality will engage the public.
Gotcha.
So when are you and how are you?
Yes,
Yeah.
understood. Okay. Questions on that one? Councilor Malante?
In your recommendations, action items section, it mentions a policy must be reviewed at least once every 4 years.
Yes, it has since been reviewed in 2013. That review itself was outside the 4-year gap, the 4-year range. So, but I mean, I realize that's not a past gap, so that's a going forward. It has to be every 4 years.
Thank you very much.
All right. Page 15. Any questions on that? 16, 17.
17.
Okay.
Yeah. For the special meetings, I circled it, and I don't know why I circled it. Carry on, and it'll come back to me.
All right.
I saw you circle when I talked about all of council present to approve the change
Oh, for a special meeting or for a meeting period?
for a special meeting. And that's honestly, unfortunately, there are councils that could use this to say, I'm calling a special meeting, and this councilor says, I'm gonna not come, because this is all we're talking about, I'm gonna go to my kid's 5th birthday party. And then they get there and council says, actually, we're talking about this, this, and this. And they've managed to exclude that person.
Okay, so just for clarification, so I'm totally clear, the, what what's the word I'm looking for? The announced purpose, the agenda of that meeting. Council is here or is not, as long as we've got quorum, but no change can happen to that agenda unless 100% of council is in attendance.
Correct.
Not approval of those that are here, but 100% attendance.
Correct.
Okay,
So that everybody is aware and nobody's getting sandbagged and discussion. And matters are being discussed behind the back of another counselor.
yep.
Counselor,
Councilor Belmonte, thank you.
So if somebody wanted to add last minute agenda items and that one or two counselors weren't there, can't do it.
On a special.
On a special.
In a
Special.
special meeting, yes, of
yeah.
course. That's what we're talking about,
Yeah.
so, thank you.
All right. Anything else on 17? Nothing come to your head yet? Okay,
No, that's probably it.
okay. 18, 19?
Yes. So, just to make it very clear, it is not up to, just for the authority to act is what I'm referring to specifically. It is not up to the CAO to recommend that we cancel a council meeting.
the CAO can suggest to the mayor, I don't have anything to cover,
Right?
but the only way to cancel a council meeting is through resolution. Now, having said that, if somebody calls a council meeting and nobody shows up, your procedural bylaw probably covers that eventuality.
Okay. And then I noticed that the minutes of January 8th, 2025 reflect that the special council meeting was held for January 8th, was canceled without a resolution of the
That
council.
was a typo. And I apologize, that went through about 9 levels of review. And I can get a corrected note on that.
Well, there was a regular council meeting on January 8th of this year.
Okay,
We'd have to double check.
I'd have to double check the minutes. Yeah, there's,
But
or,
the special meeting was on January 6th.
We'd have to double check.
we'd have
I
to
know
double
for a
check.
fact that is, I was in Mexico.
Oh,
The January
right.
6th special meeting was to discuss
Right.
the departure of the CAO. Allegedly, there was a meeting on January 6th, because.
Right, and I believe I've seen those minutes. There was a reason that it was written that way off the top of my head without it in front of me, but I can certainly send a clarification on that matter.
I think, just if I may, and this is sort of, I mean, the regular meeting of council this year was January 8th, if I'm not mistaken, right? January 8th? That's correct. And that was a Wednesday, January 6th was a Monday, and that, so which one was canceled?
Without checking to figure out how those notes
There's
reflect,
video.
I will check and get an answer back to you.
Yeah, because I don't remember either of them being canceled
yeah.
off the top of my head, but
Yeah,
I don't recall.
Okay, I will check to figure out why that is reflected that way. But I absolutely understand why you're confused and wondering what we're going at. There was a purpose for writing it at the time. But again, I will check our, yes, I understand.
Both of those meetings were.
I understand.
Departure of our CAO,
Yep.
so.
And if I haven't, once we get that clarified, I will, of course,
Thank you.
send out the thing, and I apologize for the confusion.
Okay.
If council does not mind me taking out some technology, I may be able to get the answer to this question.
Thank you.
Cool, are you okay if we move on and then we'll come back?
Please.
Yeah,
Okay.
you'll need Wi-Fi.
All right, so that was 19. 2021.
I have a question on page 20. The concerns the voting as of, requires a counselor to vote until required or permitted to abstain. So you can abstain, but you don't need to recluse yourself?
A counselor can abstain if they have declared a pecuniary or conflict of interest. A counselor may abstain if they've missed part of a public hearing. A counselor must abstain if they have missed all of a public hearing. Those are the only 4 circumstances, and in this circumstance, the reason given for abstaining was not on that list.
Thank you.
All right, anything else on 20 or 21? Okay, 22, 23, I do, no, I don't have a question. I just made a note that the pecuniary interest or the conflict of interest must specifically be stated, not just the fact that I have one. Okay. Councillor Harris.
In
you-
these types, oh, thank you. In these types of circumstances, when a situation arises that there's question whether or not, you know, a pecuniary interest perceived or actual exists, is it our lawyers that we consult with, or can we phone municipal affairs and?
We cannot make that determination, and the
Okay.
minister has no authority.
Yep.
If somebody says, I think this counselor had a pecuniary interest and they voted anyway,
No, it's just generally sort of.
No,
the,
unfortunately.
Am I in or?
no, and that's up to the discretion of the counselor. And declaration or failure to declare a conflict of interest is not grounds for disqualification.
Yep.
Failure to declare a pecuniary interest is.
Okay, no, that's good.
And
Sorry.
just to put this in perspective too, I've served as a member of council myself in my career, and I actually had a lawyer on retainer during that time to be able to bring questions of conflict.
Yeah, as do we.
Pecuniary. I had my own lawyer for that.
Oh.
Because it is your personal responsibility individually as councillors. That doesn't mean that you can't use the corporate lawyer for this, but it is your responsibility as an individual. So I actually had my individual lawyer on retainer for this.
Okay.
Sorry.
And sorry, follow up on that one, just to be sure I'm clear, because I think I am, but I want to be sure. If a counselor that I believe has a pecuniary interest, but they don't claim it, I can't challenge that at the time, correct? I may be able to ask, but I can't force
You
anything.
could ask, you can't force anything.
Okay.
The correct remedy for that is the courts.
Okay. Councillor Barry, you had something?
When someone does declare a pecuniary interest, are they required to leave council chambers or not?
I believe that's worded as a may.
It's yes, unless they have some sort of reason to be in council chambers. So like, they may be part of a body that's bringing something to council. So they would have, as the public, a right to attend and be able to present on that. Similar idea, like if they're somehow involved in that, they could, in principle, and it's in the MGA specifically, where you can remain in council chambers or even specific circumstances where you could speak to council about it. But the pecuniary interest or the conflict of interest must be declared, and in most circumstances, that councillor will need to leave the room.
Okay, and sorry, one more, just,
No.
again, just kind of some
That's
finer
okay.
details. I'll give you a personal example, because I've recused myself on a couple of grant motions where I had a pecuniary interest in it, but it was an interest in one of like 6 that we were granting. I'm assuming I am still, or should, recuse myself for the entire portion, not just the one that I'm interested in.
That's probably more nuanced than we could. I mean, somebody could make an argument either way, and that's not something that we could determine.
Okay,
If I was a CAO, I would recommend that it be broken down into different resolutions.
oh, interesting, okay.
And that portion, that lets that member. That would ensure that you know for sure you're voting when you should,
Yeah.
and that you're recusing yourself when you should. But again, that's just an
It's a
option.
nuance that isn't
It's a
necessarily
nuance
covered.
that isn't necessarily covered.
Awesome, thank you. All right, Councillor Harris.
This is on page 23 for the passing of bylaws. 2 questions. When it says that, the third, I mean, I understand the first, second reading, and then pause for that reading, or that motion, and then, okay. Is it the motion to hold, carry forward with third reading, that, you know, is that unanimously with all council present, or is that unanimously with all 7 or however many of council?
It's the unanimous of the quorum that is present.
That's present, okay?
Yeah,
No, that's,
and some municipalities say, Councillor Smith voted that council unanimously consider. That's not, doesn't meet the requirements of the legislation. It has to be passed. Council could say, we unanimously agree that we're all going to wear party hats for today, but that doesn't mean that everyone's going to vote in favor of it.
okay,
So just putting the word unanimously in the resolution doesn't meet the legislation, it has to be carried unanimously. Everybody votes.
Okay, my second question is that, for the bylaw procedures, are there specific sections of the MGA indicating when and what type of discussion can be held in closed session pertaining to bylaws and what shouldn't?
The MGA doesn't speak to that.
Okay,
That would be a question for someone more familiar with, and this isn't our legislation, so we can't speak to it, on the Access to Information and Privacy Act. I'm still getting used to that. FOIP rolled off the tongue. ATA doesn't really roll yet. I'm still working on that. But the provisions within the, what can be covered in closed session are very, very specific. So it would depend on whether it fell under those, and it's not something we can, the MGA doesn't speak to it.
okay, the only reason why I ask is that, you know, I mean, the one that you cited in here, ALT 1-25 was a borrowing bylaw. And the whole discussion was carried out in a closed session. And then when the meeting reverted back to the, you know, the open meeting, it was just the, motions were made and voted upon, and Bob's your uncle, right? But no discussion was conducted in public. So
Again, it would.
where would we find those, you know, those provisions on what can be discussed? Because bylaws, I mean, bylaws are little mini laws, right? So, you know, I think that's important, if you could sort of.
I understand why you're making the distinction, and I understand why you're making the distinction with respect to that particular bylaw. I can't assess whether or not it fell properly under the provisions of the then FOIP Act or not. That's outside our purview.
Yeah.
But again, the MGA doesn't say it. I mean, overall, I couldn't speak to whether it's good practice. It's certainly not a common practice.
Okay,
But that being uncommon doesn't necessarily make it irregular.
sure. Okay, thank you.
All right, anybody else for 22 and 23? All right, 24, 25.
Your worship, my apologies.
Oh, found
If I
it.
may, I have an answer to the question.
Oh, good.
Although it's a weird answer.
And my apologies, can you remind me what the question
Yeah,
was?
canceling of the January 8th,
Right,
January
right.
6th, something.
And this was, we're going back to page 7, no, sorry, we're going back to, thank you, 19.
So this is, you're gonna laugh at this answer, but this is the answer that I have. On page 4 of the minutes of the January 8th, 2025, there is Resolution 25-018, Deputy Mayor Sandal cancels the special meeting scheduled for January 8th, 2025 at 12 p.m. And that's all it says. So,
Oh, I remember. Yeah, I do remember.
So,
Oh, was
but
there
it,
supposed to be a special meeting held after the January 8th?
There was a
meeting?
potential one,
but it was
yes.
in fact canceled with a resolution?
I'm not showing it carried, though. This is the thing.
Oh,
So-
yes, that's why.
Yeah.
The resolution wasn't adopted.
Yeah, yeah, I vaguely remember that.
That would be why. So it was canceled, but
We may have decided, we just didn't vote on the decision,
Okay, well,
Or a recording error.
or recording
a
error.
recording error.
I don't,
well.
yeah, I
well,
don't know.
That will be interesting to discuss going forward, because as far as
Thank you.
the meeting was called for the 6th.
There was one on the 6th, but we thought at the time there may be another one on the 8th. And it turned out that it wasn't required.
Oh, okay, I just didn't get any of that.
So, yeah, so it was,
I have the
Of that.
meetings I have the meeting minutes of the 6th as well here, which happened, were adopted, et cetera, so.
Good, and I guess the reason why I was just a little confused there is that I was aware of the January 6th meeting. I was not aware of any January 8th special meeting that was called. So if it was cited in the minutes
Yeah,
as
that'd be
being
interesting. I don't-
canceled, when was it called in the first place?
And that off the top of my head, I don't recall.
Okay, well, you have access to the mayor's email, so perhaps you could look, that'd
Okay.
be great. Thank you.
All right, so I think we were done 24, 25. 26, 27, I do have one relating to the bylaw enforcement officers, and you said that they had to take an oath of office for the municipality. Is that the municipality that they are employed by? Or in the case that we are in, we contract out to another municipality's bylaw, do they have to take both theirs and ours?
They would have to take one for every municipality that they operate in. The says, I will carry out the duties of bylaw officer for the blank. So they might have had to stand and raise their hand 5 times, depending on how their contract reads.
Perfect. Which I was pretty sure it was, yeah.
Yes.
Councilor Malonte?
Yes.
So would that mean any orders or tickets issued prior to being sworn in, would that make it null and in effect? For the
That's a question to
administration of
ask your
justice?
lawyer. The MGA doesn't say what the remedy would be in that case.
Okay, thank you.
All right, any other questions on 26 or 27? All right, 28 was a continuation, so 29, I do have one. Meetings by electronic means. I just wasn't clear based on some of the things you said. Are you saying that we have to have a requirement that allows a council meeting to exist electronically? Or just the live streaming for public to be able to see, like?
There is a new requirement, and this actually was due in April 30th, that there be a bylaw that allows public hearings to be conducted electronically, and that includes allowing members of the public to participate, speak, and make presentations.
Just on public hearings, okay, got it.
Yeah.
Yeah, and I'm fairly confident we do that now, but I would have to double check on the bylaws. Sorry, any other questions about 29? All right, 30?
Acting Mayor, what I'm gonna suggest is maybe we can put, this document to be discussed further at our meeting on Wednesday, cause there's a lot to digest
I have
here.
no doubt we're gonna have additional questions after today that I was gonna ask you guys later. We could probably reach out and ask.
Of course.
And even
Of
discuss
course.
amongst ourselves.
Absolutely.
Of course.
There's a lot to digest in this. I think today we're just going over what's off the top of our head.
Yes, of course.
Cool.
I would not be surprised or chagrined if administration emailed me a list of 45 questions by 5 o'clock on Wednesday.
Actually, maybe not a dumb question. Do you have a preference? Can we email individually? Would you rather we go through administration? Is there a preference you have?
Nothing specific in the grand scheme of things. It is probably better to compile it as opposed to, if we've got 6 members of council and a number of administration and you're all hitting us with individual questions as they come up, it could be quite overwhelming for us versus if we can compile this.
One or
together.
2 emails that are compiled versus 7 emails that have individuals could be a little easier
That
for you.
being said, though, if you need to give us a call or an email, you give us a call or an email. We're always happy.
Okay.
Yeah. I will just put something for council's advisory. I am out of the office for Tuesday, Wednesday, and Thursday this week. So my out of office refers to Kevin. So if you have any questions that need an immediate answer, he will be available to respond to that.
Awesome, thank you. Okay, so again, knowing that we'll probably have some on the operating budget, are there any that came out off the top of your head for 30 or 31? Okay, 32, 33.
Oh, no, I'm ahead. Keep going.
You're good? Okay. Anybody else? 34, 35.
Just on, with regards to the designated officers, is there typically a number that there should be, based on, say, population or whatnot? Okay.
No, at the start of the MAP program, there were 5 required designated officers. However, after doing several reviews, the team made a recommendation to the legislative side, did some red tape reduction and reduced that number to 1, and that would be your assessor.
Okay, good, thank you.
There's no barrier to having more, just a reminder that they must be reflected in the audited financial statements. The number has to be included.
The reason why I ask is because that's quite a serious position that holds a lot of responsibility, you know, including the signing authority and things. So the less people that have that authority, in my opinion, you know, the less chance of,
Well, you can also limit the authority of a given designated officer. Some municipalities like to make their bylaw enforcement officers designated officers because they have certain authorities to enter property, to deal with nuisances and disturbances and unsightly or remedy. But their bylaw says these are the specific authorities this designated officer has.
oh, okay.
In one of my municipalities before coming to municipal affairs, and it's a smaller municipality than the town of Gibbons, we had 7 designated officers. But again, very specific powers and authorities for each individual designated officer. So it's whatever suits you in your municipality.
Okay, good, thank you.
All right, any other questions on 34, 35? 36, 37? 38, 39? 40, 41?
I will go first.
Okay.
There's a lot to absorb on this page.
Maybe we should just table this one and have a good old read and research and then get on.
I agree, there's a lot on here.
There's a lot of information.
Yeah.
Yeah,
Yeah, we tried to make it readable and very comprehensive, while just strictly identifying this is the gap, this is the remedy.
Yeah.
the only thing that I would ask that's kind of a sort of a yes or no question, if a borrowing is pertaining to a capital project or property or item, let's say a property or, okay, or a building, for example, should the borrowing bylaw be in coordination or noted anywhere in the land use bylaw?
Not necessarily, no.
You know what I mean? So if we're, and the reason why I ask that, if we're taking out a local improvement tax, borrowing, you know, asked to pass a lit borrowing bylaw or an off-site levy, borrowing bylaw that is for a property, a piece of land, then it just, do you know what I mean? It would be, maybe that's just something that we can look into.
No,
Yeah, you normally wouldn't note it in your land use bylaw, it'd be normally noted within your administrative accounting software
Okay.
and everything else on that property roll, so that they know what's going on.
Okay.
yeah, land use bylaw, it's sort of in the name, it's the use of the land.
Right, right.
So, yeah, there's often no link aside from whether or not it's an approved use of the land with respect to the development and any subsequent borrowing bylaw.
Okay, the other thing that I have, actually 2 questions, hang on, budget, let me just write this down, so I don't remember lose my, question for my second one. If there was a borrowing bylaw or a request for, a purchase that was made 2 years prior, and the way to pay for that item was via our line of credit, okay? And then 2 years later, nobody remembers that part, okay, because it's 2 years ago. But 2 years later, that item, we didn't buy it back then. We just got approval to buy it back then, okay? Let's say a pickup truck. We were asked by the administration to authorize the purchase of a pickup truck via and the way we were gonna pay it was our line of credit. Fast forward 2 years later, that same item comes up but we forget about it, okay, to purchase the pickup truck, but we pass a borrowing bylaw for it, right? So, I know that there are a couple of situations like that. When money is borrowed for, whether or not it be operational or capital expenditure, is the borrowed money included in the budget as as revenue? Do you understand what I'm saying? So if we're gonna buy like, where would it be noted on the capital budget, where that money comes from?
On the capital budget.
Just for example.
In your sources of funding. So like your capital budget would say, we're building a wastewater treatment plant, it's $10 million, and we're getting $6 million from the government, we're getting $2 million from reserves and $2 million from operating. You would specify that in your capital budget to say, these are my sources of funding for this project.
Okay,
So a
Correct me, sorry, but correct me if I'm wrong, you've already identified in here somewhere, we're missing that on ours.
Yes, bearing in mind in the example that the counselor provided, that arguably the truck, a pickup truck is not an operational expense, it's a
no, I
capital
said capital in
purchase.
particular.
Yeah,
Right, so your capital budget is not, it allocates funds, but it's not necessarily what you would call a spending authority, that is your operating budget. So any funds that are coming from operating must be transferred to capital, and capital budget has to receive them.
Okay, that part
So if you're budgeting $100,000 to buy a really shiny pump,
yeah,
and you're funding it out of taxes, that money has to be transferred to the capital budget. And the capital budget has to show that it had a transfer from the operating
there
budget.
needs to be a line item out from operating or
Into
from
capital.
budget into capital of a
Yes.
line in.
Yeah, like you
Yes.
might have in Public Works then, a transfer to capital project.
I've seen that before.
$25,000,
Yeah.
and
Yeah.
that's your truck, so to speak, then, that is
Yeah.
receiving that.
oh,
But then capital also needs a receiving end of
The
that
capital
Yes.
should
to
show
account
that
for it.
Funding
Yes.
is coming in from
Yes,
your operating.
and that is one of the very specific things that we look at. When you look at the budget item, it'll talk about, one of the things that we specifically review is, does the operating budget show the amount to be transferred to capital? And conversely, we look at the capital budget, does it show the amount to be transferred from operating? Because again, your source of truth with respect to taxation is your operating budget. So you
okay.
can't raise money for a capital project if it's not included in your operating budget, because that's what you're taxing for.
Okay, and can you use capital money to, can capital money be applied to operational at all ever?
When you are taking out a debenture.
Yeah,
So like in your budget, you're gonna have money set up for operating for capital, and you guys can move that money around as you see
Right.
fit, through resolutions and such. But when it comes to borrowing, when you do your borrowing bylaw and it says that we're gonna have a borrowing of a $3 million line of credit for operating purposes.
yeah,
You stated what your purpose is. It's for operating purposes.
yeah,
So you can't use that money to fund a capital purchase or fund a capital project. Conversely, if you put a borrowing bylaw that says that we're gonna do $1 million for this underground work on these streets, you can't take that money and use it to fund operations, because you've said, this is what I'm using and this is what I'm borrowing money for. Money that you borrow has to be used for the purpose that you say you're borrowing it for.
okay,
In the event that that happens, and it has happened in other municipalities, it is, the minister has no authority to order it corrected. The courts, after 30 days have passed, have no authority to order it corrected. So, again, it's a go-forward item.
okay. And you know what, part of my issue with all of this is that, back at and just, bear with me one moment, please, council, if you will. When we requested anything, municipal affairs to step in to this, in the first place, like I said at the beginning, it was not for a legislative compliance review. It was for municipal inspection. And so, the point in time is really great, and except for the fact that there's stuff that happened historically, that as the, inspectors may not come across. And the other thing that I sort of, have a concern about is that this process didn't include a council. And we asked for, municipal inspection, and it was Minister McIver that indicated that it was gonna cost us $1 million if we, request that, or make that, request as a municipality to conduct it to municipal affairs. And we were also told that in this review, if anything came up that, that had, came or produced red flags to the inspectors yourselves, in doing so, you can recommend a municipal inspection, and it would not cost the town anything, or it would be, more affordable for the town. But if you don't talk to the council in order to find out the information why we called the municipal inspection in the first place, and you only speak with the administration, and the administration is the reason why we called requested a municipal inspection in the first place, then what information are you getting if you don't talk to the people that asked you for the help, the elected officials that asked that?
So,
municipal affairs.
with respect to your question, and having undergone this process, and at the start of the process, I mean, we're aware in municipal affairs of the 2 debt limit extension requests, one that was granted and one that was not.
We had one granted?
It's my understanding there was, Jordan?
We didn't find
Oh,
out
oh
that
no, maybe I'm thinking of a different municipality that we did.
we actually didn't get, we.
Right,
we
right,
asked
sorry, I'm
for-
thinking of another municipality I was thinking of a different municipality.
We asked, just to clarify, we asked for a debt limit extension April of 2024, and we were told by the CAO for the entire year up until the time that we met with Minister McIver in March of this year, that it was still ongoing and no decision had been made. When Minister McIver requested us to meet in March with him, that is when we found out that he had declined the request for the extension 6 or 7 times, if I recall. That's what he said. So if there was an extension to our debt
No,
limit.
you're right, there was no extension, I misspoke, I was recently working with another municipality who did in fact, so I apologize for that, that was my misspeaking. We were aware of, we looked at the audited financial statements, I'm sure, and if you talk to administration when we came, we had quite a thick list of documents that we felt needed to be reviewed and might have been areas of concern. We weren't sure where the status of the borrowing or the debt limit and a few other, how the municipality had arrived at the point in time where they were there. A municipal inspection might have identified missteps or that might have gotten the municipality where they were by June 12th. A municipal inspection, given the status of where we are at this point in time, would not have been able to produce any different recommendations than we have.
How can you say that if you don't have all of the information from all of the people involved? I mean, I can guarantee you that I have information that you don't know.
We can't take action against previous employees.
I never said that. That's
Okay.
Your part.
Fair?
But going forward, we're going to have a new council sitting here in a month's time, and if the new council isn't aware of what the elected officials are at the mercy of the CAO and administration. We're only told where the CAO and administration choose to tell us. So if we are requested or are tasked with the huge responsibility of voting on how much money we can borrow, how we're going to borrow it, we rely solely on the administration to inform us of that. And so historically, if I, for example, having 12 years of experience as a counselor, know for a fact that practice has not been done, and I'm not suggesting that the current administration has anything to do with the information that I have, or perhaps the wrongdoings of the past. Number one, they should be informed that that's not how things are supposed to go, and B, it should be made very aware to the current elected officials and the upcoming elected officials that that's not how things happen going forward. So, I appreciate when you say that the outcome of your findings wouldn't change whether or not it be a municipal inspection or a legislative compliance review. But I don't think that that's a fair assessment when you don't have all of the information from all of the people that have been involved. So that's just my
I'm gonna turn this to you.
No, and I mean, obviously, I understand. A legislative compliance check is not a municipal inspection. They are different processes with different outcomes and different scopes in the whole 9 yards. I obviously did not sit in that meeting between this council and the previous Minister of Municipal Affairs, but I do know from some of the conversations that existed and such, a full-fledged municipal inspection would have been expensive to the municipality, and we also know that there were challenges potentially with that at that particular point in time as well. We would not be close to a resolution if this was a municipal inspection. And I want to be clear, not close to a resolution in this. There would probably be another 3 to 4 months at minimum of investigative work leading to a long process of procedural fairness, reporting steps, etc. And at the end of the day, my honest opinion, it might have identified a few other things that existed in the past. It might have identified a few things that, because we are a point-in-time review, that we don't go back and we don't look at something that a rescinded bylaw or an already repealed bylaw. We're not going to look at those historical types of pieces. But at the end of the day, an inspection is still going to say these are the things that are incorrect and these are the ways that you need to go about in repairing them. I completely understand and respect that this council has had some significant challenges with your administration over the term of your office. And I get that this is a challenge that exists in municipalities in Alberta. The CAO-council relationship, as I'm sure you've seen in the media, the Premier has had some comments about this, other municipalities, other councils have had comments about their CAO relationship, and as we all know, we're heading into election season, and my guess is we're going to once again, as the election goes, we're going to see 30 to 40% turnover of CAOs in this province. Because new councils will come in and think that their CAOs are the reason behind everything, and sometimes they are, and sometimes they're not. But there will be a major change in CAOs. I get that, you're looking for more. You wanted a more robust, you wanted a more, hey, these are the pieces in the past, I know that this one thing didn't happen over here. This is where, and this is why a lot of the changes have even come when it comes to council orientation now. Where council orientation used to be a voluntary practice of council. You may attend, orientation. Now it's a must. And now it's not just a must, but it's a must on 2 different occasions. There's certain information that you need to get right before the organizational meeting or at the time of the org meeting. There's other information that you have to have as of your first meeting of council. I understand that sometimes the train comes off the rails. And we're kind of sitting here in a post-derailment and we're trying to determine, where did things derail and everything else. But that's another area where that becomes for your next council, is making sure that they're getting that proper education, making sure they're getting that education and roles and responsibilities. And at times, getting that education to understand when's the right time to go, yes, we agree with something that administration is bringing forward, and when's the time to ask another question. Or to, and learning some of those extra pieces. When it comes to a borrowing bylaw, I've served as a councillor, and the first questions that come out of my mind is, where's our debt limit? Does this fit within it? And, so those are those are your responsibilities as council, and those are the types of things that hopefully these updated education are going to help. This report is going to help you and your next council in the future. It may not identify everything, but it's going to identify lots of areas where the train derailed. And it's going to bring up lots of things where, these are potentially holes for policy, where maybe you're going to implement some new policy things that administration will need to bring forward when it comes to borrowing or a local improvement. Or maybe it's going to be a change to how things are presented in council, or maybe it's going to be a change to how your administration operates on these topics. But those are ultimately your decisions as council. And I know that it's a brick wall. I know that the learning curve is, because I've gone through the brick wall myself. But we're hopefully bringing that more robust for training. We're hopefully bringing that more robust for pieces. And you do have a blueprint now. It may not tell you exactly how it went off the rails, but it tells you where it went off the rails. And it gives you that roadmap to be able to bring those policies in place.
would it, I have could the next council request a municipal inspection?
Yes.
Okay, that's first of all. Secondly, it is within the next council's ability, just like it was ours, to do an independent forensic audit.
Absolutely.
Okay, and that, I mean, if a municipal inspection was granted, you know, in the next term, can an audit, a forensic audit, can it be either one? Can the province conduct one or a third-party auditor?
We generally
What,
do not conduct forensic audits.
okay,
In general, that is not our thing. We have kind of, sort of, once,
Yeah.
kind of touched into it, but it's not our normal practice. The one thing I will say to you, Councillor Harris, and potentially to the next council, is there's nothing stopping the next council from asking for an inspection again, and it would probably be granted after this process, considering that you're into a new council and everything else. The question that I would ask for council to consider is, what do you hope to achieve with it? And I understand, again, that you might want to know that, you know, the former CAO did this, or you might want to see that my former admin, or this was a process. There might be some minor pieces, but again, I'm going to, like, just something for that council to consider is, what's the end product?
and I, you know I completely understand, and I appreciate what you're saying. I don't think, and this is why I think that this process sort of, lacked a little bit, and not just the process itself in not involving the council. I mean, I myself have gone personally to the RCMP commercial crimes. So if in the event that you know, an legislative compliance review or an audit, like a municipal inspection, wouldn't bring that up. I mean, if there's potential criminal activity or fraudulent activity or embezzlement or whatever the case may be, then a forensic audit, in fact, would uncover that, which is that's why I made the motion to request the municipal inspection in the first place.
Yeah.
Because that's my belief. So, just so, you know, there are several of candidates that are sitting in this room today, paying very close attention.
And
Yeah.
if there's potential of criminal, that again would basically not be us. We're here to help processes. We're here to help you going forward and build a robust and transparent and accountable and well-managed local government. We're not here, and an inspection is not here to assist in a criminal investigation. That is its own process, its own, and that would be in the case if there's fraud or embezzlement or things like that you are concerned that happened, that's a forensic audit.
Okay, no, I appreciate that, thank you. It's just like I said, a little while ago, the elected officials are sort of at the mercy of the administration. We only know what we know, right? And that allows for, or potentially can allow for, a
Yeah.
lot of derailing.
Yeah, if I can amplify on what Kevin has said, there was a case about a decade ago where a municipal inspection did identify something that they felt may be a criminal matter. The ministry contacted the RCMP, and the RCMP basically said, we need to hear it from the municipality. So a municipal inspection will not necessarily lead.
I wasn't suggesting that the minister
Yeah.
give the, you know, superintendent of whomever in the RCMP division, you know, a shout and say, hey, can you look into these folks?
Yeah, yeah.
I figured that, but the information that was garnered through, an inspection, municipal inspection, would at least be the starting point for, any type of law enforcement. It could be. Right.
It could be.
Yeah, right. Like, I mean, like you just said, if there was 10 years ago, there was a situation that the inspection did uncover some, you know, items that were,
Possibly.
you know, possibly.
Yeah.
Then I would hope that once that's brought forward to the council of the day, that they go, holy smokes, perhaps we should call the RCMP, right? You would think. So anyways,
Yeah,
thank you.
yeah. The ministry has only done one inspection that was finance focused, and that was Chestermere, and the cost for that, as minister indicated, was $990,000.
Just out of curiosity, why would it cost the municipality money municipal affairs, the whole ministry is there to be able to help govern municipalities run their, efficiently and effectively. Why would it cost us?
So the simple statement is, we have a policy. And, because otherwise, to be quite honest, there were times where this happened in municipal affairs as past, where anything, anytime, anything remotely went sideways in anywhere, it's, let's get an inspection. And that starts to cost the province and the taxpayer a pile of money as well, too.
Yeah.
So we have a policy in place that if a municipality, at least in principle, has capacity to pay based on their revenue, then they are responsible for either some or all of the cost of the inspection. And as I recall, for the revenue levels of the town of Gibbons, you would be fully responsible for those costs of an inspection. And so it also begs the question in that sense that if you're paying the inspection, this
Oh,
is
no,
something
put up
then the
or
council
shut
can
up.
do
That's
as
what I'm
well.
saying. If you
No,
want-
I'm not saying that, but I'm just saying in general that, sure, you can request municipal affairs does an inspection. We come in, we send in a third-party consultant, we do we set up the contract, they come in, they do the inspection, they give you a report, we send you a bill for whatever the amount is, and when we send you some directives that go, thou shalt do these things, and the minister, makes sure of that and everything else. Versus the other option that exists for council is to hire one of the same consultants that we would hire for a municipal inspection and ask them to do the same type of thing that we would do, who would provide you with a report, the same as a municipal inspection at the end of the day, and it's you paying the bills, so it's,
Really, it's more-
it's still
it-
gonna
the-
be independent, and it's, the only thing then at the end is you're not gonna get directives from the minister. So if you want us to do it,
Okay.
in principle, we can absolutely, but there is absolutely nothing stopping you from bringing in that consultant and doing it.
Okay, no, that's good to know as well. It almost seems like if the municipality takes charge of it and does it themselves, then there's more control over what is looked into or
Exactly.
direction. Okay, good, thank you.
Okay, I actually have a follow-up question on that. And I may be remembering the wrong area on some of this, but you had made a mention that any of the directives, if we can make them changes immediately, we probably should, but understanding that some may take up to a year idea. But then you also made a comment here in this area that the lending agencies or the banks, whatever, may not actually allow us to make some of these changes.
Exactly. We
If
can't
we're-
require you to do something that's gonna make you violate another contract or agreement.
Do we have to get approval from you if we can't make those changes?
No.
Let us know.
Let you know, but not an approval
Yeah,
process?
yeah,
Okay.
exactly. If you're able to, and bring yourself
Do it.
back into compliance, by all means, but obviously we can't step in between that.
Perfect, perfect. All right, so I think that was 40, 41, and 42 is a continuation. Anything on 43? Counselor Sandal, looks like you maybe?
Yeah, you earlier mentioned that the town has loans to a private individual.
Yes.
And I didn't realize that we'd actually had that. Can you reveal who that was, loans were to? Or should we bring it up at the council meeting on Wednesday to go through it?
Your records show that there were, in 2018, 18 loans made to property owners for sanitary sewer lines, and again, in 2023, loans made to 13 property owners for paving their driveways.
Oh, okay, thanks.
All right. Anybody else? Okay, 44, 45. All right, 46, 47. Forty-eight, 49. Fifty, 51. Okay, this one I have. Anybody on 50 first? Because I have a 51. Okay, 51, certification of tax assessment notices. You made basically the statement that there needs to be a designated officer that signs off on it. Is there a standard who normally does that, or it's anybody in the administration?
It can be any designated officer in the administration.
Okay,
I've seen a variety of approaches. I had one municipality that just the CAO signed the mailing slip to say, yeah, see, this was done. It goes on file.
And it sounds like the only thing we are missing is somebody actually dating this is when they went out.
Yes, your CAO could do it today,
Okay, awesome.
if he so desired.
Anything else on 51? Okay, 52, 53. Councillor Harris?
This is when I had mentioned the approving authorities bylaw, that was, one of my concerns that I had actually, with the regards to the fact that the previous CAO had designated himself into these, the assessment review or the development officer and the assessment, the subdivision authority and whatnot. Is that regular practice? That to me seems like it's quite, like I said, giving the CAO quite broad powers.
It's quite common in smaller municipalities. In fact, the subdivision and develop appeal board clerk cannot be anyone with development authority, and summer villages and small municipalities have a problem because their CAO is in fact their development authority. So that means even if they have a regional pool where they all do SDAB together, none of them can sit as clerks because they're all a development authority. So it's a very common structure.
None
in
of the
small municipalities.
CAOs can sit as clerks?
Because they're already a development authority.
Okay.
So, but yes, it is very common for a CAO to be both.
Okay, and the only reason why I ask is because that was new. We had one prior to, and then carry on.
Yeah.
There is a reason why I went to the authorities, so.
Yeah.
My first posting as a CAO, I was the CAO, I was the development officer, I was the subdivision authority, I was the bylaw officer, I was the chief dog catcher, I washed bottles,
Yeah.
whatever needed to be done. And in those small municipalities, it tends to be your senior administration is doing everything.
Completely understandable.
Yeah, as municipalities grow, especially if their planning development needs become more complex, then they often hire a specialist or an agency.
Thank you.
Okay, anything else on 52 or 53? 54, 55? Okay.
With regards to the local improvement tax, did you find anything, I mean, I have to read this about 5 times before it actually, all sinks in, but there were questions on whether or not a local improvement tax should be, that is the process that should be followed in order to recoup some of the, as opposed to off-site levy. Does that make sense?
A local improvement tax pays for the infrastructure that is going into town in the present, and offsite levy is for future development.
So think along the lines of you've got a new subdivision you're putting up, and that subdivision is eventually going to need a new fire hall.
Yeah.
So your offsite levies are in theory starting to deal with those future needs so that you have the money put away for when that fire hall is needed.
Okay.
The local improvement tax is about building up that, it's about charging the people that are most going to benefit from what you are installing, the price tag essentially of installing those services. So you put in water, sewer, and roads for a development. This is then making the residents of that development pay for it.
Okay, now, if it's a new development, though, it's the end user that would pay for those roads and services that were put in.
That is
Right.
an option that exists, and you could do it through a local improvement. Another option that exists is through a development agreement, and you make the developer who's actually
Well, that's normally
building
what
the
happens,
piece
yeah.
to put in the things, and then they recover it as they sell lots and things like that as well.
Okay.
That's another method.
Yeah, what the one project that we have here was a residential development with 39 lots that I would say only 15 of them since 2019, since the development was actually created, have houses on them because it's a local improvement tax as opposed to the development agreement, and which, as you probably know, doesn't put a big fire under the developer's does not motivate the developer to, you know what I'm saying?
It could, because in theory, if you've got a local improvement tax, so that's now a tax that's going on their tax notice, or is supposed to be anyway, which then
On the developers or on the end users?
on the landowner. So if the developer, I'm assuming, is owning the land, the developer then should have a local improvement tax on that property, on that roll file, and every single year they're going to be paying a certain amount of money.
Whether or not
for
there's a
every-
house.
Whether or not,
on it.
because when you get that tax bill, that local improvement tax in principle is on that tax bill. The developer agreement is making them do it all up front. The
Right.
local improvement tax is you're getting it over a period of time. But in theory, every single lot, unless you are the lot owner, because you're not gonna pay yourself a tax, if
Oh, that would
somebody
make
else
sense. So
owns
if
the property,
if the
then-
municipality is the owner of the property, then the local improvement tax doesn't come into effect until that lot is sold to a private individual.
and potentially even, and I'm going again, please understand, I'm on top of my head here mode
Yeah.
at the moment, but even in principle, if you've got a 25-year local improvement and that property doesn't sell for 15 years, there's only 10 years left on that local improvement charge then. Because there's a specified time that that local improvement can be paid. And it's in your local improvement tax, it should be, I believe, in your local improvement tax bylaw.
So if I'm not mistaken, if it was a 10-year agreement on the local improvement tax and we didn't sell it until year 11, there's no more tax on it
Correct,
because we owned it, and in essence, we paid ourselves.
yes. Yeah, you're paying the local improvement tax to yourself.
Oh, I see. Okay, so if a local improvement tax was imposed on a new development to pay for the infrastructure build, and that land is still owned by the municipality, and therefore a developer is not paying taxes on that until that land is sold from the municipality to the lot owner, the private individual who wants to put their house on there, which that would explain why the municipality, for that local improvement tax borrowing that was taken out initially, why the municipality is paying the yearly principal and interest payment, because they're not getting any taxes.
Well, you're gonna be paying the loan no matter what, but yeah, if you're not receiving taxes over here to go to that, then it's.
Right.
out of your general
And
tax
one of the notes is that the borrowing did not include the interest charges.
Yeah,
Borrowing did also not include the fact that there is a municipal that some of the land is municipal, so it is in fact a municipal contribution.
well, how can, oh, no, thank you.
Okay, that was 54, 55. Anything else? Okay, 56, 57.
With regards to the tax recovery auctions, what were your findings there? Anything specifically that you know raised your?
With respect to tax recovery auction for residential properties, we didn't note any concerns with the people liable to pay being notified and then either it going to auction or entering a tax sale. However, the process, administration hasn't done that required process yet for designated manufactured homes.
Okay, and what's the? I didn't know we had. Does it was it just that like a wording in the bylaw that you found, or did we actually sell a manufactured home?
No, when there is a residential property in tax arrears, a lien is registered. There's processes that have to be done in terms of notification. A lien is registered with land titles against that property. And then there's a time span that has to be done, additional advertising in the Alberta Gazette, the calling of the auction, the setting of the auction price, a whole number of mandatory steps. When you're dealing with a mobile home, the steps are a little different. Instead of registering with land titles, it's registered with registry by the VIN on the manufactured
Okay.
home, and the information has to be provided to the owner of the
Trailer park or the
Thank you,
the park,
thank you,
yeah.
yes, yeah. So there's a few additional steps with respect to that.
Okay, and is there, I just, when, if a tax auction is, you know, if we're, council is, if it's brought to the council's attention, those, does that process have to be, is that by resolution of council? To hold go into a tax recovery?
It's a mandatory process.
Okay,
But you will set a resolution for the date of your auction,
Yeah.
reserve bids, things like that.
The conditions of sales and that kind of thing, but whether or not it goes to auction is not a decision of council.
okay. Whose decision is it?
The legislation, the
Oh,
legislation.
it goes to auction, period.
Period.
Okay, so if council approves a sale or a going to tax auction, in order, like, what can stop that? Just full payment of the tax arrears?
Yeah. Or an agreement
Okay,
to
and
pay it within 3 years.
is that agreement, does it have to, after the, like, I guess what I'm trying to say, is it just an email, hey, council, we're not gonna go through with this auction anymore? Or does it have to be brought back to council in an official
Well, council should be
capacity?
notified, but council doesn't have any role in making the decision.
In making the decision as to whether or not it continues, or making the decision as to whether or not it stops?
So if they pay the tax arrears, or
Yeah.
if they enter into a repayment agreement, that stops the auction.
And council,
Okay.
yeah, and council should be notified, by the way, this is struck off the list.
Yeah.
But that's it.
Okay, all right, no, that's good, thank you. Did you, I guess, did you also, there was a notation in here for the sale of town land or buildings as well, right?
Yes, there are certain requirements. If it's being sold for less than market value, it has to be advertised.
Yeah.
But we found that, and there's no definition of market value. Generally, it's considered to be a realtor's assessment, the appraisal, or the assessment, the appraisal, or a realtor to determine the market price. And as long as one of those three happens, then it's fine.
But in order to be approved to be listed under market value, that has to be a resolution of council?
You would be setting the date of the auction.
No, she's talking
Yeah,
about
just
sale of-
as sale of a
Right,
of land
yeah, you
or
have you have a house, you don't think it's gonna sell for $100,000, council
Yeah.
wants to offer it for 60, that's a council resolution and 2 weeks of advertising.
Oh, okay, good, thank you.
The exception is if you are selling it to a nonprofit, there's no advertising required.
Okay.
All right, that was 56, 57. Anybody else? All right, 58, 59. I do have a question. You had made the mention on the tax agreements that we had some that were exceeding the 3 years.
And they weren't exceeding it, it wasn't clearly spelled
Oh, it
out in
wasn't
the agreement.
cleared.
Yeah.
Gotcha. Okay,
So we couldn't tell, but
you couldn't tell whether we were or not?
Yeah, yeah.
Okay, I don't know whether I still have a question or not, though. I guess the question is, if we have a signed agreement that doesn't spell it out, do we have to get a new agreement, or do we just not from this point forward have one without?
to bring it under compliance, I would say that it has to be redone.
We have to redo the agreement?
Yes.
Okay,
Now, it would be up to a lawyer to decide whether it starts over again or whether it carries
Yeah,
on from that
does-
point. That's not our
does
thing,
your-
but
do
it
the
is not
3 years
compliant.
start
You do
today?
not have a valid agreement at this time,
gotcha.
if it does not specify the 3 years or 36 months or whatever.
Okay. Anybody else on 58, 59? 60, 61? 62, 63? Councilor Belmonte?
Back to 61, I just cribbed some notes here. 14 days to 21 days includes that requirement piece. Is there a reason why? I see you smiling, so
Actually, I can actually answer this question.
Thank you.
Shockingly enough, is previously it was 14 days from the date of receipt of the letter, and the Interpretation Act requires 7 days for the letter from the date of mailing to be received. So the change to the legislation requires you to mail the letter at the time of the decision and gives 21 days, which is 7 days of receipt and 14 days of appeal, just put into one period now.
That makes sense. Thank you.
Makes sense. I've learned something.
Awesome. Okay, so that was 61, back to 62, 63. 64, 65. 66, 67.
If we can just back up to
Oh.
the 65, what I will do is I will send your administration some examples of municipalities that have published or examples of how they've described their hierarchy. We recognize that municipalities are busy and administration is busy, so there is a process that is referred to as R&D, rip off and duplicate. So when there are questions about bylaws or procedures and we have found something that is compliant, we share those.
Awesome. Thank you.
Before you go, I have a question on the publishing policies and stuff. Because in this community, we have no public papers or anything, what is the best way for us to actually inform the public? And do we need to then, a bylaw or a policy to reflect that this is how we're going to do it in the future?
So with respect to publishing the planning decisions, that has to go on the website. So far, there's only been 2 things required to be on the websites. The world is changing, apparently. It's planning matters and then the new intent to run, which just came out this year. Those are the only 2 things that are required. If you do not have a local newspaper, you go to section 606.1 of the MGA. You can set up a bylaw for alternate means of advertising, and that will cover all of your forms of advertising. You can say that you're going to post it on your door, you're going to put it on Facebook, you're going to put it on the website. It will cover all whatever options you want for non-newspaper means. It does require a public hearing, and it is not valid for, I think, public auctions. There's one area of the legislation that still requires a newspaper.
All right, thank you. That was 64, 65. 66, 67. 68, 69. And I think we kind of stopped there because the rest was just discussion only with a lot of information that I think we need to read.
Yes, lots and lots of information. I mean, this is included as a reference, like this little cheat sheet on when it's okay to add amounts to the tax roll. And you don't have to dig around through the MGA and figure out where it is.
Anybody else, any other questions? Councilor Malante.
I know that we don't have a local newspaper, but we do have around us, surrounding us. Would that be applicable in some cases? Because I've known some municipalities to advertise in a local paper outside of the municipality, but within their county.
Do they have circulation in here? Are they sold here in the municipality?
Don't think so.
Because usually the legislation speaks to having circulation in the municipality.
Okay.
Just to say out loud, kind of on that topic, when we were here talking to your administration a few months ago, specifically, we had a discussion about the requirement that still exists when it comes to some of the notices for recovery auctions. And obviously then the Edmonton Sun, Edmonton Journal being the only newspapers that have circulation here, and that coming at an extreme expense to the town of Gibbons to be able to do those notices. And I just wanted to say out loud, following that conversation with your administration, we identified this to our policy and legislation. So we can make no promise of a legislative change. That's obviously up to the legislature and the minister and such. But we have identified this as an issue that is negatively harming our municipalities. And we know that you're one that it's
Awesome.
harming, so.
Thank you. All right. Any other questions?
So, yeah, so from our perspective, the next steps are that, there's 8 weeks for administration to develop a plan. and then submit that plan to us. It can be as simple as a spreadsheet, a checklist. The digital version is a fillable PDF if administration wants to go that way. Given the fact that this was requested by council, I would be unsurprised to discover that council has a few things to say about, what they want to prioritize or how they want to do things. And, and the plan can take up to a year, and we are always at the end of the phone or at the end of an email if council has anything, or rather administration has any questions or wants us to preview something to make sure that you're back on track and not sliding into a ditch.
It's always the joke, but we are from the government and we are here to help. And we do mean that.
Yes, very much so.
Awesome. Anybody else? Okay, well, firstly, I want to say thank you so much to the two of you and your team that worked on this. This has been incredibly enlightening. I think in the long run, a very positive results so far. But again, like you said, I think we've got some reading to do and some comprehension to try and undertake. And we will likely be in touch with some questions, it would be my guess. For council, by all means, somebody to make a motion, but my thought is motion for information today, and then we can start discussing on Wednesday's regular council meeting to see what maybe our next action plan might be. Councilor Barrett,
So you're asking for a motion to accept this report as information?
if that's the motion you choose to make.
Done.
All right, questions?
Are we going to have this added? I don't mind making that motion and voting on that motion as long as it's going to be added to the agenda for Wednesday's meeting.
Can we do a friendly amendment to add this as an agenda item to Wednesday's meeting?
Or how do we go about, how
Or
do we
is
go about that?
I would suggest the council just add that as an item. I'll have copies ready, and it's gonna get posted on the website anyway. So I'll have copies ready, and tomorrow on Wednesday, make that addition to the agenda.
Very good, thank you.
Awesome. Okay, then if I heard you right, then Ms. Pino, we don't need an amendment. Okay, perfect. Awesome. All in favor? I think that is carried. And with that, we are adjourned.